Good morning, friends. This is Dr. Sumit Pahwa, and welcome to the webinar on GST Tribunals, masterclass on GST Tribunals. So let me begin by offering a small introduction about myself, then the author and topic, and then we'll hand it over to the author. So, Rajat, are you there? Rajat, you're on mute. Yes.
Yes, hi Sumit.
Hi, Rajat. Hi. So thank you, Rajat, for joining as a speaker on the webinar. And here we begin the webinar now. So, friends, I am Dr. Sumit Pahwa. I am a corporate lawyer and company secretary with 25 years of experience in legal and compliance domains. Currently, I'm the co-founder and CEO of COMPLINITY, which is India's leading compliance software, helping companies comply with the laws of the country. COMPLINITY covers more than 2,500 laws and a checklist of over 38,000 compliances, which are updated on a daily basis. COMPLINITY is adding value to 1,000 plus companies in India and more than 13,000 users spread across 100 plus industry verticals from organizations like Panasonic, Max Hospitals, Oberoi Hotels, Toyota, Yes Bank, British Council, and 1,000 more companies, covering all the laws which apply to all the companies in India, be it central laws, state laws, industry specific laws, municipal regulations, etc. Joining me is the speaker today, Mr. Rajat Mohan. Rajat is a seasoned chartered accountant and a senior partner at AMRG and Associates, one of the premier tax consulting and advisory firms in North India. Rajat is an acclaimed thought leader, and his articles have been featured in leading dailies like Times of India, Economic Times, Hindustan Times, etc. And he's a prolific author, having authored a book called GST for Corporate Leaders, which is running in its 10th edition, and GST Case Digest, which is running in its 6th edition, with publishers like Thomson Reuters, Tax Sutra, Walters Kluwer, etc. Rajat is also a member of PhD Chamber of Commerce Indirect Tax Committee, ASSOCHAM, National Council on Indirect Taxes, Indo-German Chamber of Commerce, Indo-French Chamber of Commerce in Industry, and is also welcome Rajat to the webinar, and thank you for accepting our request to be a speaker to share your knowledge.
Thanks, Sumit. Thanks.
Yeah, and brief about the topic is that this, as you all know, the central government on the recommendation of the GST Council, wide notification dated 31st July, constituted the Goods and Services Tax Appellate Tribunal called GSTAT, which are much awaited actually, with effect from 1st September 2023. So it was retro dated with effect from September 23. However, the same have not yet been sort of come into force, and the government is still sort of constituting the benches, etc. Now, it is envisaged that there will be a principal bench at New Delhi and a total of 31 benches across all states. However, they are not yet operational, but they can be operational anytime now. What we hear, and Rajat will, tell us, but it looks like in the next, maybe by March 25, the tribunals are expected to be operational. So it's very important to understand the much awaited tribunals, their legal constitution, what will they handle, how will they handle procedures, whatever is there in terms of acts and rules right now. Rajat will share his sort of expertise on that. And the webinar will cover legal provisions on CGST, including the creation of GSTAT, several benches, the tribunal's jurisdiction, procedural rules, powers, filing appeals, preconditions, etc., etc. So this is the brief. Before I hand over to Rajat, a small poll I would love to run. And here we go. Very quickly, if you could fill up the poll. The first question is, do you have experience in dealing with GST compliances oblique cases? And what describes you best? Are you a practicing professional or a general counsel or legal team, CFO, finance or tax team, in-house company secretary, compliance professional, or others? This will help the speaker understand the nature or the complexion of the audience, and therefore he'll be able to, Rajat, you'll be able to see the response and accordingly know how much technical you should be and you should not be. Okay, I'll just wait for 5 more seconds if we can fill up before I end the poll. Okay, so I'll end the poll and share the results So 83% have experience in GST compliance cases, and 31% are practicing professionals. 44% are in-house CFO, finance team, or tax team, and the balance, is other categories. All right. So Rajat, that gives you an idea. And over to you, Rajat, for your
Perfect.
presentation. Yeah.
Thanks, Sumit. And Sumit, one more thing, the people do have a lot of questions. They can punch in the chat box, right?
Yes, so not chat box. Yeah, thanks for pointing. So Q&A box, you can see. So people can anytime during the presentation, whenever you have questions, you can put it in the Q&A box. The structure of the presentation will be that for an hour or so, Rajat will run through his presentation and share the entire expertise and information. And towards the end, last sort of 15, 20 minutes, 25 minutes, we'll try to take all the questions. So please keep punching in your questions, and we'll take it towards the end of the session. Yes.
Perfect. Thank you, Sumit. So,
Yeah.
guys, thank you so much for inviting me here. And the topic is GST tribunals. Mr. Honorable Finance Minister has said number of times that in November 2024 the tribunals will kick in. The work is going at a very fast pace. I can tell you from my own sources. Recently, Revenue Secretary has said that it will be, started by the end of Feb or March. So we have couple of months before the tribunals kick in. Now, appellate authority have started processing your appeals at the appellate level itself. Now we see a lot of cases will be moved to GST tribunals. Cases will be shifted from High Court. People have applied a lot of cases in the High Court, filed red because tribunals are not there. These cases will be given back to tribunals. In other cases, a lot of backlog is there in appellate authority, whereby decisions were not made, eyeing that tribunals are not there. Now the pace has taken up, and we'll see a lot of decisions in appellate authority in next 1 or 2 months, so that enough cases would be there in tribunals. For professionals, we see a big opportunity in GST tribunals, and our today's presentation will try and cover basic parts of tribunal, what it is, how it will be formed, where it will be formed, the functions, the benches, etc. Everything. So first of all, GST Appellate Tribunal, also known as GST 80, is constituted by a central government. Legally speaking, there are two acts under GST. One is CGST, and another is an SGST, like Delhi GST, Maharashtra GST, etc. Powers to constitute a tribunal has been given by both the legislations to central government. Thereby, GST 80 will be constituted by central government. In July 2024, government came up with a notification saying that GST 80 is established in September 2023 with retro effect, because they had to do a lot of things and hire people, take places on lease, make appointments, do RFPs. So they don't want anyone to go into it and say the procedure was not followed. So that was one of the key reasons to implement or form tribunals with retro effect. How will GST tribunals be structured? Ideally speaking, GST tribunals will be structured in two parts, whereby part of one, the main part will be principal bench, and the other benches would be the state benches that will function under the principal bench. Principal bench will be in the state of Delhi, and the state benches will be in different states like Maharashtra, Tamil Nadu, Chennai, etc. And now, what would be the structure of the principal bench itself? So there will be one principal bench in India. Principal bench will have one president, one judicial member, and two technical members. One technical member from the central government and one technical member from the state government. Technical member from the state governments are selected under SGST law. They are SGST technical members from the state boards itself. The technical member center selected under center is from central government, selected under CGST. We'll have one president and one judicial member. We'll see what education, what qualifications they use to have. Now, on the request, so these are all sections from the CGST. On the request from state government, every state government need to give a request to central government, after which they will form state benches also. So ideally, first of all, the principal bench is the responsibility of central government. They will form this bench, and the formation of the state bench is also the responsibility of the central government. But what happens is a request needs to be given from the state government, right? which they have already given it. Right. So we'll have separate state benches for every state. So now let's see, this is the notification that has come up in August 2019 and then in November 2019 also, which says how many state benches where all it would be given. So first we'll have a state bench in Andhra, Bihar, Chhattisgarh, Delhi, Gujarat, Dadra Nagar, Haryana, Jammu, Ladakh, all these places we'll have a state bench. Karnataka we'll have two. Goa, Maharashtra put together we'll have three benches. Punjab, Chandigarh, Rajasthan, all these, Kolkata, West Bengal, Sikkim, Andaman together they will have two benches, right? So these are the benches. So first of all, we can also see the location. So the location of Northeastern will be in Guwahati. We'll have only one bench. So there is a circuit or a sitting. So if we have a lot of cases in the seven sister states, then we will have additional benches in Aizawl, Agartala, and Kohima. Similarly, for places like Uttar Pradesh, right now we'll have three benches at Lucknow, Varanasi, and Ghaziabad. If there are a lot of cases in Prayagraj and Agra, we'll have additional sitting space or additional circuit. You may say this will be operational as and when President says. Once we kick in with these 31 benches, then only we'll have more sitting space if there are a lot of cases in these places. All right. These are phase one benches. I understand phase two benches request has also been forwarded by states to the central government. They want more benches. So let's see. First, we have state one benches. So the principal bench and state benches will hear all the appeals for the orders passed by appellate authority or the revisional authorities. What is the structure under GST? The structure under GST is pretty simple. You go to a tax officer, he adjudicate your matter, he says whether tax is payable or tax is not payable. If he says tax is not payable, you are happy. If he says tax is payable, and if you are not happy, you go to first appeals, also known as commissioner appeal under income tax law, also known as first appeal, also known as appellate authority under GST law. So this becomes commissioner appeals or first appeals. Appellate authority, you go, he decides whether tax is payable or tax is not payable. If they decide tax is not payable, you are happy. If they decide tax is payable, then what happens? If you are not happy, then you go to appeal to or income tax appellate tribunal. Under income tax, under GST, we'll have GST appellate tribunal, GST 80. Right? If there is a decision against appellate authority, so it becomes ideally appeal to level. So all the cases with regard to place of supply, as you already know, is the place where the taxes are being deposited, because there is a conflict of interest between various states on this matter, whether the tax needs to be deposited in Delhi or Haryana or Maharashtra. This could be a conflict of interest area. There were all such cases which belong or which has an issue of place of supply will be heard by only and only principal bench. There was a notification in September 2024. All anti-profiteering cases will be heard by principal bench only. No state benches are allowed to hear place of supply or anti-profiteering cases. But as you may know, on 31st March 2025, anti-profiteering cases will no longer be picked up. The DGAP will be resolved. And the last date to file your applications under anti-profiteering is 31st March 2025. After that, तो कोई case वैसे भी नहीं आना है. I believe all these current cases that were currently with NA, then shifted to Competition Commission of India, will now be shifted back to the GST Appellate Tribunal Principal Bench. The government may, on the recommendation of council, notify certain other cases also, which will only be heard by principal bench. As of now, no notification has come. However, down the line in future, we may see certain cases of search and seizure whereby multiple searches and seizure are made across various states in big corporates. These may be heard by only principal bench, because for a GST is a state case, you cannot have 10, 20, 30 cases across India. Normally in search cases, we pick up a lot of cases across a company in various states. So these may be bundled up and given to principal bench. As of now, there has neither been any indication nor a notification on this. Of course, the president is empowered by general order or a special auditor to transfer certain cases from one bench to another bench. See, so now we come to the principal bench is headed by a president, right? A state bench is headed by a vice president, and the is the senior most judicial member within a state bench as has been notified by the central government. So vice president of a state bench will not be chosen by the state government, will be chosen by the central government. This is the important point. Administratively, principal bench president is the boss for the principal bench. Similarly, vice president is administratively the boss for the state bench, although he's the senior most member. So senior most judicial member is also required to be notified by central government. It's not that with the accretion of law he automatically becomes the VP or the administrative in charge. It has to be notified. As of now, nothing like this has been notified for any state government. So how many people? So we have seen that I think we have seen this. Let me, so every principal bench will have one president, one judicial member, two technical members, one from center, one from state. Similarly, every state bench will have two judicial members, one of which will be vice president, and then two technical members, one from state and one from center, right? Now we come to this point whereby every appeal is to be heard by two members. One will be judicial member and one will be technical member. The technical member may be center, technical member may be state, right? It may depend upon what are the internal procedures, guidelines, etc. that has been made on this. However, if the matter is not a big matter, it's a small matter, it's a matter up to 50 lakh rupees, and there is no involvement of any question of law, in such case, a single member may also hear the appeal. But these are decisions to be taken by the registry. You will normally, so as a taxpayer, it does nothing changes for you. You normally go to the registry, file your appeal. In this case, most likely the appeals would be filed online on the portal of GSTN. You don't have to worry who will hear the appeal. It will automatically be decided by a registry. But I'm saying up to a 50 lakh rupee case and a question of law not being involved, it may be heard by a single member. Normally what happens whenever we go and file an appeal in the initial couple of years, there is always a question of law. So I believe in starting, two members will be hearing your appeal. What happens if the members don't agree? If a members don't agree on a state bench, then in such case, another member from a state bench may be involved, or another member from a different state bench may be involved. And based on that, a majority opinion will be decided. मतलब पहले के दो members और अब का तीसरा member, whosoever decides in majority will be decided. Matter in a principal bench, another principal bench member will come on board, will hear the appeal, and then those three members will decide. Or if there is no other member in the principal bench, then other state member may come. But the idea is the president of the principal bench cannot decide, or the vice president of the state bench cannot decide any matter. If there are dissenting opinions, it has to be taken up by the majority opinion. This I will, so yes, it is little important. What happens is bench either is to be judge of a high court or a district court with 10 years of experience. We see a lot of judicial members being appointed. We may see from district court itself. We may not have so many retired judges from the high court. Or he may be an advocate with 10 years of experience in indirect taxes. Technical member center will be an IRS Group A officer, completed at least 25 years of service. Technical member from the state will be an officer from state government, completed at least 25 years of service. Among other conditions, these are the two major conditions. Now, state government may not have enough people to send it to GST Appellate Tribunal. In such case, they may make a request to the GST Council for the relaxation of such requirements of 25 years. It can be made. A person who has not completed the age of 50 years will not be eligible for appointment as a president or as a member. These people would be senior people, that means. Now, I'll just stop you here and I'll take you through, because what happens is we are going for GST Appellate Tribunal, right? So GST Appellate Tribunal is nothing but a refined version of CSTAT, which was Custom Excise Service Tax Appellate Tribunal. For the erstwhile laws that existed in indirect taxes before 2017, the tribunal was named as CSTAT. For GST law, the tribunal is named as GSTAT. Although to be very clear, CSTAT is functioning. CSTAT is not dysfunctional because there are already a lot of pendency in CSTAT. Similarly, once GSTAT is formed, CSTAT will continue to function for the old cases, as well as we may have certain new cases in the cases of customs, in the cases of tobacco, alcohol, petroleum product, whatnot. There are very few items that are still chargeable to excise as well as customs, right? So let us draw. So first of all, with effect from whenever the GSTAT comes into play, it's not like CSTAT will be wound up. It's they may not be even at the same places. It's nothing like that. The certain cases of CSTAT will be transferred to GSTAT. Nothing like that. Establishment, yes, like GSTAT is established under CGST Act. CSTAT was established in under Customs Act 1962. As of now, we have one principal bench in CSTAT and 8 regional benches. Under GST 80, we'll have one principal bench and 31 state benches. It seems to be very high. From 8, we are moved to 31, but this is not the case because ideally the powers of the VAT tribunal has also shifted. There were a lot of cases in the VAT tribunal which will continue to function. Again, I am saying all the cases that were earlier parked in VAT tribunal now will come to GST. Thereby, there has to be more number of benches under GST 80. 31 will it will not end with 31. Members, every bench and CSTAT used to have one judicial member and one technical member. There was no involvement of state, thereby it only had 2 members. Whereas under GST 80, we'll have 4 members, 2 judicial members and 2 technical members. And then the bench could be of one judicial and one technical. Qualification, there is a difference between qualification under CSTAT. The person would have 10 years if you are hiring a judicial member. The person would have a 10-year experience of any judicial office or a member of Indian legal services, more than 3 years, or an advocate of 10 years. If you'll see here in GST 80, he has to be judge of an high court or a more than 10 years. Not any judicial officer. This we may not find so many high court judges. Thereby, we have to restrict ourselves to a district judge. Technical member center. Earlier, it was same as IRS. Group A, commissioner, principal commissioner, 3-year services. Now, with this, additionally, what we see is additional condition of 25 years of service. He must have completed 25 years in IRS. Similarly, there was no conditions for state level officer. Now, the similar conditions are there for technical member state also under GST 80. Who can be a president under CSTAT? A judge of a high court or one of the members of the tribunal could be a president. Whereas this is not the case. GST 80 is a big authority. Judge of a Supreme Court or a Chief Justice of a High Court. So earlier there could be any judge of a High Court. Now it is only a Chief Justice of the High Court or judge of a Supreme Court that can be act as a president, right? So under CSTAT, any member can be appointed as vice president in CSTAT, whereas this is not the case under GST 80. It has to be senior most judicial member only. Okay, so these are what are the eligible orders. Custom service tax, we have certain orders. Commissioner appeal, majorly commissioner appeals can go into appellate tribunals. Under GST, we again have appellate authority decisions that will be challenged. This is important. Appellate tribunal's discretion. So appellate tribunal, if there is a case of INR 50,000 rupees, appellate tribunal may refuse to even admit an appeal. Whereas this limit is with CSTAT. अगर आपका केस 2 लाख रुपए से कम है, CSTAT में से I will not hear. Under GST 80, it's only 50,000 rupees. क्योंकि अब VAT के डीलर्स भी आ गए, इसलिए limit has been reduced to a little. Fees for filing a case in CSTAT. Earlier there was a fees of minimum fees of 1,000 rupees, maximum fees of 10,000 rupees. Now the fees has been increased to 5,000 minimum and maximum 25,000. This is under CGST law. Same fees is applicable under SGST law also. Thereby minimum fees will be 10,000, maximum will be 50,000. I feel this fees to be on a very higher side. especially in first couple of few years, whereby there we are expecting a lot of litigation even by MSMEs. Government may think of giving a rebate or certain kind of discount on filing fees. At least it should be bought in parity with the CSTAT, at least for first few years. Fees for rectification, if there is any error in the appeal of order, then there was a fees of 500 rupees with CSTAT. Now there is no fees. The decision of mistake apparent on the record, CSTAT, an order used to be passed in 6 months. Now it has been halved under GST 80. Within 3 months, you'll get an order. The time limit for disposal of appeal with CSTAT was 3 years. Now this has been reduced to 1 year. You can expect early orders. However, the law says as far as possible. So these are not mandatory limits. These are only recommendatory, but we have moved from 3 years recommendation in CSTAT to 1 year recommendation in GST 80. These are not all right. So okay, so next we go to a little bit of procedure, and after understanding the differences between the two, let's go to the procedure before the appellate tribunal. What happens? Appellate tribunal, while disposing of any proceeding before it, will not be bound by the procedure laid down under CPC. The Code of Civil Procedure has a very detailed guidelines with regard to summoning and witness and documents, etc. But tribunals are not, although they are quasi-judicial bodies, still they are not bound by the procedure laid down in CPC, but they can dispense with the procedure.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.
Why they are not bound by CPC when our authorities have made a CPC procedure? Ideally, they should also abide by the CPC procedure. Why they will have their own regulated procedure? So I'll answer. So what the best way to understand is go to the current CSTAT law and see what are the difference between CPC and CSTAT, how they function, and why CPC is not applicable to CSTAT. So first of all, CPC is a general law for suits in India. आप और मैं लड़ाई करते हैं प्रॉपर्टी के ऊपर, आप और मैं लड़ाई करते हैं रिकवरेबिलिटी के ऊपर. You and me are fighting over certain aspects of a contract act. This becomes a civil procedure matter. Thereby, we need to have a very detailed guidelines of who will produce what summon needs to be given, how will they be approved, how will witnesses come, how will witnesses go, how will there be any payment to witnesses being called, or it will not. So there are a lot of things that need to be discussed, whereas under CSTAT, this only the matters that we'll be discussing only relates to indirect taxes. And on one side we'll have a taxpayer, other side we have a government department, those who never have any conflict of interest. So when you and me are fighting as two individuals, we always have a conflict of interest. I'll always want the money, you will always want the money, or you will always want certain assets to be given to you, I'll want certain assets to be given to you. Whereas in case of a CSTAT or in case of an income tax, the cases relate to taxes on which the other side does not have any conflict of interest. Even if the tax is imposed or tax is not imposed, nothing is coming to them. So they are expected, I'm saying they are expected to be more fair as compared to issues that we see in civil suits. Initiation of proceedings under civil suits have a very detailed guidelines with regard to filing of complaint, service of summons, appearance before the court. Whereas in case of CSTAT, it's usually the written documents, notifications, circulars that are all available and certified on the government portal. So there is no need for much to discuss on witnessing, on cross objections, etc. Chartered accountants, cost accountants cannot represent in civil courts, whereas they can represent in CSTAT. Burden of proof always lies, in case of a civil court, always lies on the person who institutes the suit. जिसने केस करा उसके ऊपर burden of proof है. Whereas under CSTAT, the burden of proof always lies on the taxpayer. Taxpayer has to prove how a wrong tax has been imposed on him. We see detailed guidelines in civil suit with regard to evidence, examination, cross-examination, admission, rejection of evidence, whereby CSTAT mostly relies on documentary evidence, which is always certified from the government. It is a simple book of act, so it's more legal thing that we discuss. Proceedings are adversarial. We know that fighting there is a conflict. They always, whereas CSTAT is more informal, people does not have any conflict of interest. Execution of orders. The civil court requires a separate procedure involving execution of orders regarding attachment of property, etc. Usually CSTAT orders are carried forward by tax department itself. There is no need of separate procedure for separate discussion in the courts itself for the execution of a civil. Court fees is based on the value of the claim, whereas under CSAT there is a very nominal fees, 5,000, 10,000 that requires to be paid. Yes, powers of an appellate tribunal, although what we have read till now, that they are not bound by the procedures, right? They are not bound by appellate tribunal, but bound by the CPC. However, there are certain matters in which what we discuss about the powers are the same that are vested in a civil court under the Code of Civil Procedures. So these are 1, 2, 3, 4, 8 matters on which, ideally 7, rest is another amount. 7 matters for which the powers existent in the appellate tribunal will be same that of the Code of Civil Procedure. So we have taken up all the powers and given the order numbers of CPC for which power you need to verify which one. But again, it's about the courts, and courts need to see. Let us not get into that. This is a very important point, and this is a very big differentiating point as compared with CSTAT and appellate tribunals under GST. Any order made by an appellate tribunal may be enforced by it in the same manner as if it were a decree made by a court in a suit pending therein, and it should be lawful for the appellate tribunal to send for the execution of its order to the court within the local limits. Problem कहाँ है? CSTAT में it has been held that the tax is required to be disbursed by the taxpayer, तो वहां पे काम खत्म हो जाता है. उसके बाद local tax department will pick up the case and get the taxes deposited from the taxpayer. In appellate tribunal, because this is a federal structure, we have GST officers, we have CGST officers, we have SGST officers. We don't know, or probably the law itself or the council doesn't know, that the local officers of the state will take something very seriously or not. Thereby, for the first time, an appellate tribunal has been given the entire power to enforce or execute their cases also. For example, if a local don is being apprehended and he is required to pay certain tax, the local tax officer is scared to execute that order and recover taxes from him. In such cases, I'm only giving you a case, although the power has given in the appellate tribunal wherever they feel so. If their order is not being executed, they may refer the matter to a local court for the purpose of execution and attachment of property and recoveries, etc. This power never existed with CSAT. This has been given for the first time to a tribunal under indirect tax laws. I see no reason has been given. The only reason that I see is a more of a federal structure. So in certain areas, the local tax officer may not be very good with the recoveries. In such cases, the appellate tribunal may give the cases to the court itself. Okay. Very important point, 1114. All proceeding before appellate tribunal is a judicial proceeding. What does it mean? It means two sections are applicable, which says if any person has intentionally given false evidence during the entire proceeding at appellate tribunal to appellate tribunal, then such person may be imprisoned for a period up to 7 years and he shall also be liable to pay a fine. ठीक है, अगर आपने जानबूझ के कोई भी false evidence दिया appellate tribunal को. A, B. Any person whosoever intentionally offers any insult or causes any interruption to any public servant, जब केसेस कर रहे हैं आप डीआर को वहां पे appellate tribunal में, any public servant, you may be imprisoned for a period of 6 months plus a fine which may extend to 1,000 rupees. ना तो आपको फॉल्स एविडेंस देना है और ना ही आपको किसी को इंसल्ट करना है, और यू हैव टू कॉल इंटरप्शन टू एनी पब्लिक ऑफिसर. पर्सन, सो आपको अपील फाइल करने के लिए गेट 3 months टू फाइल एन अपील. There is a period of 3 months. The entire process has been made by, will be made by GST and online. So it will be very simple, whereby any order decided against you by appellate authority, you just have to go online, log in, you have to file your documents, file an appeal to appellate authority, and it will be filed online only. In certain cases, the registry may allow filing of documents on manual basis also. Can an appellate tribunal refuse to admit an appeal? Yes, appellate tribunal can refuse to admit an appeal if the amount of dispute is not more than 50,000 of tax. They may refuse it. It is not compulsory. For appeals, an individual get 3 months to file an appeal to appellate tribunal. For departmental appeal, department will get 6 months to file an appeal to the appellate tribunal. Departments are generally considered to be slow as compared to an individual. Thereby, instead of giving 3 months, they are being given 6 months. Can they file manually? Yes, subject to permission from registry. Very, very important point. Memorandum of cross objections. Yes, this is very, very important. So what happens? So let us not discuss this. First, let's discuss this. There is an order from appellate authority. Let's suppose the total quantum was for 1 crore rupees. Out of that, the appellate authority says that 60 lakh rupees is decided to be paid to the government, meaning thereby 60 lakhs is applicable tax and 40 lakhs is exempt, meaning thereby it is not a one-side order, because every matter will have several matters involved. So in this matter, there are 10 matters involved of 10 lakh rupees each. 6 matters taxpayer loses and 4 matter taxpayer wins. Meaning thereby 60 lakhs is what he has to deposit and 40 lakhs what he doesn't have to deposit, right? Now the applicant to the taxpayer goes and files an appeal for his own 60 lakh rupees. He'll never file an appeal for he files an appeal for a 60 lakh rupees, right? Now in this case, the department has also lost 40 lakhs, right? Department may go into another appeal. On the same order, can we have two appeals? Answer is yes. A department may go in an appeal on the 40 lakh rupee matter, which they have lost. So for 60 lakh, taxpayer is filing an appeal. For 40 lakh, department is filing an appeal. Both the appeals will be heard by the same bench on the same day, and two different orders will be passed in this case. What happens if the taxpayer files and the taxpayer doesn't file an appeal, but department files an appeal for their 40 lakhs, because department has to file within a period of 6 months. So after completion of 3 months, department files an appeal because they have 6 months. Now taxpayer doesn't have any way out because he has already accepted 60 lakh rupees. He has not filed an appeal. Can he do anything? He cannot do anything. The only thing that now available with him is memorandum of cross objection. If department has filed an appeal for 40 lakh rupees, within a period of 45 days, the individual or the taxpayer can file a memorandum of cross objection, and there he can say that, boss, because you have filed this 40 appeal against 40 lakhs, thereby I am instituting another appeal kind of a thing against the 60 lakhs. So I can bring that 60 lakhs back on the table, which has to be heard by the appellate tribunal, and the entire decision for 1 crore rupees has to be given. So what is an MCO? MCO is filed in response to an appeal by the opposite party to contest specific aspects of original order if they were not independently filed in an appeal. Can a memorandum of objection be filed only by a taxpayer? No, department can also file. Right? If it was not instituted in an appeal individually, then it can be filed. It functions as a counter appeal. It functions as a second appeal in part of the same proceedings initiated by the appeal. However, as of now, it is rarely being used. Department or the individual taxpayer always file their appeals on their own matters. It is only when one files but second one does not file and there is no time limit still available, then only MCO will be filed. Rarely used, but yes, this is the problem. Hmm. Can a tribunal condone the delay in filing of an appeal? Yes, 3 months for taxpayer, 3 months for departments, 45 days for memorandum of cross objections, right? डिपार्टमेंट की ओरिजिनल अपील फाइलिंग के लिए 6 महीना है बट एक्सटेंशन के लिए सिर्फ 3 महीना तो 6 months plus 3 months whereas taxpayer has 3 months plus 3 months. Department total gets a 9 month period. Fees for filing an appeal minimum 5,000 maximum 25,000 1% of the tax or ITC has to be the right. Preconditions for filing an appeal, one of the very important point. What are the preconditions जिसकी वजह से appeal चल लगेगा ही नहीं? First of all, if there is any tax that you have admitted or any interest, fee or penalty which you have admitted, then in such case the admitted liabilities which includes tax, interest, fee, penalty, fine is required to be deposited in full. 100% is what you have to deposit. If there are certain taxes which you do not agree, meaning thereby these are disputed taxes, then 10% of such disputed taxes is required to be deposited, subject to a maximum of 20 crore rupees. Right. Hmm? Admitted tax liabilities, you have to deposit 100%. Disputed tax liability, you have to deposit 10% of the disputed tax. But ये थी, I think this was known to everyone. But एक बहुत ही खास बात है. There is a basic difference between the CSTAT appeal and the GST appeal. Under GST, it says no appeal can be filed under subsection 1 unless you have deposited admitted tax and you have deposited 10% of the disputed tax. Whereas the Custom Act reads, if you'll see, there's something marked in yellow, the tribunal or the commissioner appeal, as the case may be, shall not entertain any appeal. Meaning thereby they cannot entertain, but the appeal can be filed. There is a difference. प्री कंडीशन फॉर फाइलिंग एन अपील, अगर आपने प्री डिपॉजिट नहीं करा तो आप अपील फाइल ही नहीं कर सकते. दूसरा, आप अपील फाइल कर सकते हो बट अथॉरिटी सुनेगी नहीं. अपील विल नॉट बी एंटरटेन. देयर इज अ बेसिक डिफरेंस बिटवीन CSTAT, that is custom, excise and service tax, and the GST appeals. What this law, they cannot entertain, but the appeal was filed. So let us suppose एक आदमी के अगेंस्ट 1,000 करोड़ का टैक्स हो गया है, 1,000 करोड़ का टैक्स बना दिया गया है, तो उसका 10% हो गया 100 करोड़ रुपए, बट मैक्सिमम जमा करना है 20 करोड़ रुपए. 20 करोड़ रुपए जमा कर दिया और उसके बाद अपील सुन ली गई अंडर GST. अगर ये 20 करोड़ रुपए जमा नहीं करा जाएगा तो अपीलेट ट्रिब्यूनल के अंदर अपील सबमिट नहीं हो सकती. आपको कहां जाना पड़ेगा? हाईकोर्ट के पास रिट ज्यूरिसडिक्शन में ही जाना पड़ेगा. रिसेंटली और पहले इससे ज्यादा, whereas in CSTAT what used to happen was 1,000 करोड़ का केस है, आपको जमा करना 7.5%, 7.5 था, तो 7.5 करोड़ रुपया तो जो भी बनता है आपका वो आप जमा कीजिए. और अगर आपके पास पैसा नहीं है तो आप बिना टैक्स जमा करे आप अपील फाइल कर देते. अपील सुनी नहीं जाती थी. अपील वॉज नॉट एंटरटेन्ड बट दे यूज टू हियर द मैटर कि बॉस टैक्स जमा क्यों नहीं करा है, प्री डिपॉजिट क्यों नहीं करा है. एट दैट पॉइंट इन टाइम दे यूज टू टेक अ डिसीजन कि हमको अपील रखना है या अपील को रिजेक्ट करना है. बट दे यूज टू नॉट एंटरटेन ऑन मेरिट्स बट एंटरटेन ऑन why the appeal has been filed and the tax has not been pre-deposited, right? So basic difference आ गया entertain और उसका. How does the law takes its course? Third point, is the pre-deposit required to be made from cash ledger only? Answer is no. You can pay the taxes from your credit ledger only. Also, there are two cases, Shift Crackers and Oasis Reality. In both the cases, it has been held, एक by Gujarat High Court, एक by Bombay High Court, कि the tax can be deposited by credit ledger also. Any recovery, once you deposit the amount of pre-deposit 10% cannot be made from you. It is deemed to be stayed until the disposal of the, जब तक order नहीं आता तब तक आपको कोई recovery नहीं करी जाएगी. This we have read. This I will not touch. Just like let's maybe have 10 minutes to go. Okay.
So, Rajat, by the way, we have time, so I
Okay.
think you can go at your convenience. So we have some
Okay.
time, and yeah,
Okay.
so please take your time. Yeah.
Okay. Okay. So orders of the tribunal. What happens? Every appellate tribunal shall, as far as possible, decide here and decide that in the period of 1 year. So पहली बात तो क्या एक साल mandatory period है? Answer is no. Only recommendatory period है. The appellate tribunal may decide the appeal within a period of 1 year. It is not compulsory to decide the period in the period of 1 year. ये बड़ा अच्छा सवाल आया था अभी पीछे किसी का, whether a matter decided by one state GST appellate will be binding on the another state GST appellate tribunal also. Nothing like this has been mentioned in the GST law. However, what we used to see in the regime of double AR and triple A, authority for advanced ruling, authority for appellate authority for advanced ruling, right? Similar arrangement they used to have. Every state used to have a different appellate authority for advanced ruling and an authority for advanced ruling. Whenever a matter was decided by, let us suppose a matter was decided by Gujarat Advanced Ruling Authority, was it binding on Advanced Ruling Authority from Jammu or Delhi? Nothing has been provided under GST law. Practical experience, I am telling you, they never used to even read those case law. Whenever we send to these appellate authorities, we produce those case law. They said these case laws have only a recommendatory value, only a persuasive value. They are not mandatory on us. We will not follow this, but they were read as to what reasons are being given, right? So similarly, there's no law in place. I believe the GST appellate tribunal will take its own course. Of course, the principal bench would be at a higher forum, and because the president is sitting and which is a judge of a Supreme Court or chief justice of a high court, so a lot of importance will be given to decisions from a principal bench, and it could be heard or agreed by various benches, must be in fact. Whereas I am still pretty not decided as to whether bench will agree to the decision from the another state bench. We see similar kind of issues with income tax appellate tribunal also, whereby a Delhi bench judgment may have persuasive value for a Bombay bench judgment, but they don't see it as a compulsion. Similarly, in the GST law also, because we have now involvement of state technical members, they may not be very upcoming to accept the judgment from the other state. Of course, they will have persuasive value. Will they have binding force? This is not written under GST law. Although, if you go in a lot of detail and see various Supreme Court rulings, then it is being said that if a tribunal decides something, the lower authority must follow. But two tribunals parallel, I don't think they will be obliged. President shall exercise such power as has been prescribed. Up till now, nothing has been prescribed. A lot of notifications we accept to come here. This is important. Appearance by an authorized representative. Any person who is entitled or required to appear before an officer or an appellate authority or an appellate tribunal, right, in connection with the proceedings under the Act, shall such person may appear by an authorized representative also. मीनिंग देयर बाय जो पावर जो आपका वकील जाता है या आपका चार्टर्ड अकाउंटेंट जाता है आपके बिहाफ पे appellate tribunal, वो पावर आती है सेक्शन 116 से, right? आपको खुद जाने की जरूरत नहीं है, यू कैन जस्ट टेल योर पर्सन टू रिप्रेजेंट यू। मॉनेटरी लिमिट्स, कौन से ऐसे लिमिट्स होंगे जब सेंट्रल टैक्स ऑफिसर्स अपील फाइल नहीं करेंगे, डिपार्टमेंटल अपील। एपेलेट ट्रिब्यूनल में 20 लाख, हाई कोर्ट में 1 करोड़, सुप्रीम कोर्ट में 2 करोड़, इनकम टैक्स में 60 लाख, 2 करोड़ 5 करोड़ लिमिट थी, और सी स्टैट के अंदर 50 लाख, 1 करोड़ 2 करोड़ लिमिट। ठीक है, सी स्टैट की लिमिट्स हायर थी, इनकी लिमिट। अच्छा, अब ये कुछ चीजें हैं जहां पे कहा गया कि डिपार्टमेंट हैज नॉट फाइल्ड एन अपील, इट डज नॉट मीन डिपार्टमेंट हैज एक्सेप्टेड योर स्टांस। नॉन फाइलिंग का मतलब एक्सेप्टेंस नहीं आएगा, ये सेक्शन में प्रोवाइड करा हुआ है। नॉन अपीलेबल डिसीजन, देयर आर 4 types of decisions which are non appealable, cannot be appealed. First is any order of commissioner or an authority empowered to transfer proceedings from one officer to another officer. इसके अगेंस्ट कोई ट्रिब्यूनल में अपील फाइल नहीं हो सकती। अगर देर एनी ट्रांसफर प्रोसीडिंग्स तो उसकी रिट फाइल होती है हाई कोर्ट के अंदर। पॉइंट नंबर 2, एनी ऑर्डर पर्टेनिंग टू सीजर और रिटेंशन ऑफ बुक्स ऑफ अकाउंट्स, रजिस्टर्स और अदर डॉक्यूमेंट्स, कोई भी सीजर का या रिटेंशन ऑफ बुक्स का कोई भी ऑर्डर अगेंस्ट अपील नहीं। Although it has been seen that even against these orders, writ has been filed to higher authorities. Uh, Third, है prosecution, sanctioning of. So under GST law, what happens is there is a clause, I think 129 or so. If the tax evasion is more than 5 crore rupees, then you can be prosecuted. That means you can be put behind the bars. GST officer does not have any power to only recommend to the criminal courts to institute a case against you for prosecution under GST law. So the power is with although section is under GST law, the power is given under criminal courts. The officer will only sanction the prosecution, but it will be taken up and decided by the criminal court itself, which is not in the jurisdiction of the GST officer per se. Thereby, GST appellate tribunal will not take this decision. This will follow their own life under civil courts. There are certain orders under section 80 which typically relate to extension of payment of deadlines or similar administrative relief, which are discretionary and does not involve any direct determination of tax liability. Thereby they are not appealed. सेक्शन 80 के अंदर हो सकता है आपको कुछ एक्सटेंशन दे दी जाए कि आप 3 महीने में मत पे कीजिए, 5 months में पे कर दिए, आप इंस्टॉलमेंट्स में पे कर दिए। These are very, very exceptional orders. In my entire career or last, not even seen with my own eyes a single order on this. We have heard in various high court cases, but I have never ever seen. So against, because these are discretionary power given to an officer, there is no demand that is being made against a taxpayer. Thereby, it says these orders are non-appealable orders. So you get 4 types of orders are non-appealable orders. I don't want to discuss the process. We can spend 2 minutes. There is a fee involved. 5,000 to 25,000 is the fees. Together with the fees, you need to file your form APL 05. If an appeal is filed by the department, then the form is APL 07. Manual filing would be allowed only if it is allowed by the registrar. Once you file the appeal with the requisite fees and pre-deposit, you will be given a provisional acknowledgement. Provisional acknowledgement is issued, and after that, once the order is uploaded, and you also have to upload that the order against which you are doing. But we understand this will be an entire seamless process that is being prepared by GSTN. The moment your order comes up, you can just file an appeal against the same. Thereby, no need of procedurally uploading. Right? Additional evidence is very, very important. Let's discuss this. Additional evidence, appellate authority or appellate tribunal. The rule is 112. appellants generally cannot produce any new evidence, oral or documentary, before appellate authority or appellate tribunal. इसका मतलब अगर आपका केस नीचे एडजुडिकेशन में था, आपने जो जो डॉक्यूमेंट्स प्रोड्यूस करे नीचे, मैक्सिमम वही डॉक्यूमेंट्स प्रोड्यूस हो सकते हैं appellate authority में, appellate tribunal. You cannot produce any new document, right? However, there are some exceptions. First exception, refusal by lower authority. The document that you produce, the lower authority refused to accept it, meaning thereby you must have a proof that you have tried to provide it to them. Prevented by sufficient cause, the appellant could not produce evidence when called upon because maybe you were in hospital or someone has expired at your home, thereby you were not able to produce those documents. Or there was certain natural calamity in the area through which the documents have to be procured. Supposedly you have to procure documents from Gurgaon, but there is a some natural calamity in Gurgaon or some unrest in the Gurgaon area. Then you cannot procure those documents in time. Relevant evidence is missed. Evidence relevant to an appeal ground wasn't produced. So you say that there are certain evidence that was required to be produced. Ground was mentioned, but we missed. Lack of opportunity is always same. That opportunity of being heard must be given. The officer has not given the opportunity of being. So these are the 4 exceptions in which additional evidence could be produced. However, the appellate authority or appellate tribunal shall not allow any evidence unless the sitting officer who has denied such a document is being allowed to represent and give a reasonable opportunity of being heard as to why such documents were not taken on the record. Meaning that the previous officer that has made that demand also needs to be present and tell why such documents were not. After the appellate authority or appellate tribunal, after recording the reasons in writing, may accept or reject the additional evidence. Very, very important thing is. Can an appeal before appellate tribunal be withdrawn? Answer is yes. Appeal before appellate tribunal can be withdrawn. The form is 05/07W. This is a single form. If you have filed an appeal and the tribunal has not given an acknowledgement, then it can be easily withdrawn. If the tribunal has given an acknowledgement, in such case, approval of appellate tribunal is required. Tribunal will decide whether the withdrawal required and whether withdrawal should be allowed or not. Monetary limits. Okay. The monetary limits we have discussed 20 lakh, 1 crore and 2 crores in High Court, Supreme Court. There are certain exceptions to the monetary limits. Now we are going into little detail of this. First of all, if there is any challenge to a constitutional provisions of CGST, SGST, UTGST, IGST, or even compensation cess, which is not written here, then such limits does not apply. If there are fundamental questions with regard to classification, valuation, refund, or place of supply, in such cases also the monetary limit does not apply. So what happens in certain cases, costs are imposed on the department. If there is any cost imposed on the department, certain penalty is imposed upon an individual, then in such case monetary limit does not apply. And the fourth is always the open thing. If anything that CBIC believes that needs to be challenged, then they can decide and do so. Yes, now this is little interesting but academic. CGST. So you all know that we have 2 types of laws. One is a central law and one is a state law. So central law is a CGST law. In this, every state will have a different law. Delhi GST, Maharashtra GST, Sikkim GST. So in these state law, there are very small differences. Section wise, we are covering those. First of all, in section 109, the tribunals are constituted under CGST law only. The Delhi GST law says and refers that the tribunal as constituted under 109 of CGST law, meaning thereby the tribunals, whether state tribunal, state bench or a principal bench, both are constituted under CGST law. Section 109 under CGST talks about both the benches, principal bench and state bench. Delhi GST talks only and only about the state bench. 110, President and members of the appellate tribunal, their qualifications, appointment, conditions, etc. No such provision exists in the Delhi GST law. Appellate tribunal may condone the delay by a period of 3 months. Delhi GST does not have any such provision. 114, financial administrative powers of a president. Because state benches does not have a president, so they don't need to have this provision at all. Rightly so, Delhi GST law does not have this provision. One thing is important, section 120, appeal not to be filed in certain cases. Power lies with CBIC to issue orders for fixing monetary limits for departmental appeal in case of CGST, whereas in case of DGST, power lies with the commissioner of the state. He is the senior most guy. And very few minimum issues or differences between CGST law and DGST law. This questions we can do this question last. So is there any guidelines for document printing? Will it be A4 size? Will the printing be done back to back or not? All these guidelines, etc., has not been formulated by GST Appellate Tribunal as of now. Such guidelines exist in Rule 8 of CSTAT Rules 1982. Which says that every memorandum of appeal, cross objection, the reference application, stay application, any other miscellaneous application shall be typed neatly in double spacing on A4 size paper, and the same shall be duly paged, indexed, and tagged firmly. So this is maximum what has been provided, not nothing beyond this, right? Okay, these are all. So there are certain, so there are updates, as I already discussed, that Nirmala Sitharaman has said that, we'll have a functioning GST appellate tribunal by November. I think 2 or 3 times she has said this, but very recently, yesterday only, I was seeing news by Revenue Secretary by the end of 2025 financial year, financially 2000. So by Feb or March, I believe we will see this. I have a lot of discussions with GST and certain high-ranking people, and they say that we are in preparing a portal whereby entire tribunal proceeding will be virtual. Start from filing to member sitting on the board to making a decision to filing additional evidence to reading the papers. As you can see, the high courts are absolutely online. Similar way, GST is also trying to bring everything with regard to tribunal online so that people don't face any challenges, and appeals across India can be filed on a single portal. One of the major challenges that they may see is filing of bulk of documents. In many cases, the document runs into 10 files or 20 files together with the so much of facts and documentation to be filed. So that becomes a real challenge. But GST says that we are doing. They have not done up till now. Will tribunals be operational all simultaneously, or will they have a phased rollout? I believe they will have a phased rollout. It is impossible to have a functioning principal bench as and when we'll have a functioning a state bench in Jammu or Kashmir or in West Bengal or in Chennai. It is not possible. I think it will be on a phased manner. However, nothing has been said so far. Are there any provisions for expedited proceedings in an urgent matter before appellate tribunal? As such, there is no process abhi tak under GST law or GST rules. But yes, you can always file an application to an appellate tribunal saying that my matter must be heard urgently or on priority. This will go as a miscellaneous application, as in the cases of high courts, and they will hear the matter not on merits, but why it is urgent, and then decide whether it has to be heard urgently or not. That's it, guys. Sumit, I think I have completed my session now. All the slides are over.
Right. Perfect. Thank you, Rajat. You can unshare your slides for now, Rajat,
Okay.
and you can sip a glass of water. In the meantime, what I'll do is I'll ask my team to share a small 1-minute video, and then we'll come back to Q&A.
Okay.
session. Yeah. And friends, in case you have any questions, please drop in the Q&A box. Some questions have come in. You can drop it in the Q&A box in the meantime.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.
Okay, thank you. So friends, just to reiterate, COMPLINITY is India's leading compliance software. You can see that we have 12, 13 modules, the flagship being compliance, where any compliance that is applicable to any company under the sun in India, be it central laws, state laws, municipal laws, industry-specific laws, for 100 plus industry verticals are being covered in COMPLINITY. More than 2,500 laws are covered, and of course, GST, CGST, SGST, IGST compliances are also covered, innumerable, all the compliances, apart from, of course, the income tax and SEBI, LODR, and company law and labor laws and environmental law, etc. So if you're a multinational company in India, or you are manufacturing you've got manufacturing facilities or service of any service company, and a particular threshold, say 100 crore above top, reasonable complexity, I'll ask my team to put the in the chat window request for demo. So my team, if that applies to you. Okay, so on that note, few questions have come up, and also a couple of people had raised their hands. So we'll see Sanjay, Magyar, Mr. Thangaraj, Vijay, in case you guys are available. I'll try and see and spotlight you. You can be ready with your questions. But in the meantime, let me take a few other questions. So Rajat, one question is that we saw in the slide that appeals are to be disposed of in 1 year. And you also said that this is recommendatory. So, in other forums like in IT80, for example, or even in NCLTs, as far as company law is concerned, even in insolvency and bankruptcy also, many time limits have been prescribed. But again, because of the judicial process and the timelines being none of that seems to be practically being implemented. So what is your opinion, that do you think this 1 year will hold any value, or IT80 again, with due respect, I think it takes years and years for cases to get solved. Every hearing sort of goes for 6 months or so. So what is your opinion about the timelines in this case? How do you see GST tribunals will work?
So I think first of all, Sumit, what we have to see is in the erstwhile law of customs, excise and service tax, the CSTAT authority, they were given timeline of 3 years that they have to decide in a period of 3 years as far as possible. Again, not a mandatory timeline, a recommendatory timeline. But we have seen cases coming up after 10 years or 15 years, right? So under GST, the timeline has been reduced to 1/3, 1 year. The law is new. Thousands and thousands of applications is what we are assuming to come. So can this be, is this realistic? I don't think so. Will appeals be decided in a period of 1 year? I don't think so. But what happens is usually, uh, uh, take a very simple case. For your office, you are the boss. So, right, you have to decide a case against yourself. It becomes very difficult for you. For my office, I am the boss. Case against myself will become very difficult. What happens if we merge together? So it becomes a very, very now possible that if a case against you will come, then I'll stand up and say, Sumit, why are you not deciding? Let's decide. A case against me will come and you will say, Rajat, why are you not deciding? Let's decide. So what happens with GST? It's a collaborative thing. It's now a GST council whereby every state finance minister is sitting, central finance ministers are sitting, whereby there are different political parties involved. If they want to throw some kind of garbage or dirt on each other, they can pull this up that the law provides 1 year. You have not decided this in 10 years. And because so much of data is being available, one finance minister or the other finance minister, like a Kerala finance minister or a Punjab finance minister, will give it in public domain. Ki boss, 20,000 cases are pending, which were not decided in more than 1 year, right? So these will, the democracy, I'll say, will play a lot of part in this. I don't think things will be decided in 1 year, but will be much faster as compared to C start.
Sure. Though, yeah, you're right. The intent and the spirit may be good to expeditious disposal of cases, and Chief Justice of India has been speaking about this, and even our Honorable Prime Minister also has been speaking about, and the Law Minister of expeditious disposal of overall cases in India. However, for example, 30 benches or 31 benches multiplied by 4 officers in each bench, as you said. So 120 officers. And suddenly, what I was in our discussion also when we were having a word, and otherwise also, since so many since these forums are coming after such a long time, and so many appeals were on hold. I mean, people were not deciding appeals even at a appeal one level. So suddenly, if we see thousands and thousands of cases being filed now, what will the 120 members do if suppose 10,000 cases are filed in the first month itself? So how will that human the process work? That's something to be seen actually. While the spirits may all be good. Yeah. Okay. Another question is, you also mentioned about virtual platforms, online hearings. While again, it's a welcome step, and after COVID, we have seen all the courts go online. Even there are Supreme Court judgments for all the courts should have online proceedings, etc. And we have seen online proceedings working wonderfully well, even in NCLTs also, where I and my team of EMI is encompassed. Still, even after the forums have gone online, a lot of things are happening offline. Like even in high court examples, even if the hearings are virtual, but the filings are physical, and we still see reams of paper multiplied by so many copies. Hundreds and thousands of copies. And in appeal, it only multiplies because the original, all the pleadings of the original, thing case, and then the appellate, pleadings have to go. So it remains to be seen. Again, what is your expectation? Because in NCLT also, online is only with respect to the WebEx call. Okay, online filing is there, but then it is supplemented by physical filing, and the WebEx call is there, and the it's very broken processes. It is not a portal proper. These are very broken processes. So, what is your expectation on the GST and promise of bringing everything virtual and everything in a digital format?
Sumit, again, what happens? I'll tell you a very big problem under GST. So let me come back to our topic that if we merge. So you'll ask me to come to your office. I'll ask you to come to my office. Similarly for central government and the state government, what is currently happening is it has become practically impossible to formulate tribunals in various states because of a simple reason that a central government member sitting there wants the state members to come to their office. State member sitting says central member should come to my office. Or, now the next option that you and me have is let's make a new building of Sumit and Rajat Associates, right? Who will spend? Center doesn't want to spend, state doesn't want to spend. Who will spend then? Right? You don't want to spend, I don't want to spend. This is exactly the problem that we have been facing in formulation of GST tribunals. Parallelly, what GSTN sees it as a solution. If you work from your office, I work from my office, we are not happy. We don't get a good place on the rent with all the lavish things that we want. We want our own secretariats also to be in place. Let's have everything virtual. So this is the solution that has been, although all various state governments have taken things, Dehradun, I suppose, have taken place on rent, Delhi has taken on rent. So people are finding those places and taking them on rent, but GSTN sees this as a, as a plan by in some state, we want to form a tribunal, but unable to find a place, or you are not ready to come to my office, I have any go, or I am not. So then this tribunals, this GSTN will work, and GSTN up till now, they have a great technology backup or technocrats with them.
Yeah.
So they are working whereby the entire process start, the biggest of documents could be filed online, and then the entire process could go online. So this is what they are
Right.
trying to do.
Yeah, no, it'll be very welcome and very wonderful step if the whole proceeding can be seamlessly be online, including filing without the need of any physical filings, and all the coordination and show cause names for the cause list and all everything can come online properly. Then it'll be very good. Okay, so one question is there. Some states have issued trade notices requiring assessee to intimate if they will file appeal in tribunal against order of first appellate authority. Whether or not such filing intimations bar the assessee from approaching tribunals.
So, okay. So first of all, very few orders have come from appellate authority because there were certain internal guidelines telling appellate authority not to decide cases till the time appellate tribunals are formed. So I am astonished if there are cases, but there are very few cases that have been decided. Next, in certain cases where it was decided the matter was very big or highlighted in media, etc., there were decisions. What happened was because the appeals are to be filed in a 3 months period, tribunals have not been formed. I am not able to go to High Court. I don't have so much money in my bag. What will I do? I'll have to wait for the tribunals to be formed. In this time, under Section 79, the recovery proceedings were initiated on certain taxpayers. Now the taxpayer said, "Boss, you have not formed the tribunal. Why you are recovering for me?" In those cases, central government as well as certain state governments have come up with certain notices. Ki boss, if you want to file an appeal, please inform us that you need to file an appeal, but we'll wait for the tribunals to be formed. You can make a pre-deposit till that date and we'll not touch you. So this was for the benefit of the taxpayers itself, but there's no challenge. Once the tribunal is formed, you can file your appeal.
I understand. Okay, and the next question is, what is the estimate number of cases going to come on board the GSTAT by June 2025? Will the current cases automatically move to GSTAT or will it involve human intervention?
Then sorry, so second part I missed.
So will the current cases automatically move to GSTAT or will it require human intervention?
No, so I said, so for current cases of central excise, service tax or a custom excise tribunal, CSTAT will not be given to GSTAT. This is entirely different legislation, different. This will not. And how many cases will we have till June 2000? Only God can
That's
tell.
anybody's guess. Yeah, yeah.
Yeah.
Even the finance minister will not know. Okay,
Yes.
so so another question is, can GSTAT adjudicate the matter against service receiver wherein service provider made a default of output liability?
So yes. So ideally, what happens is tribunal is a constitutional body, last body to fact-finding body, and they have a lot of power. I have already said that they can, refuse, admit, annul, cancel, do anything with the orders. The orders, absolutely.
Yeah, whatever is there, the jurisprudence develops as per law.
Yes.
They can pass against anyone. Yeah, any
They
part.
they cannot. So the only difference is the High can write down certain provisions of the law saying that this is unconstitutional. This is not what they will say. They'll
Yeah.
say in this case this needs to be done.
Right, right. Okay, what is the timeline to uh, call for hearing by the appellate authority from the date of filing?
From 3 months. Sorry,
Uh,
I didn't get it. Can you?
his question is that from when you file the appeal, maybe the first hearing, is there a
There's
timeline
no
where
timeline. There's no timeline. There is
no
timeline
timeline?
for decision. There is
Yeah,
no timeline
one
for
year,
hearing.
which is that 1 year
As
overall
far as
period. Yeah, yeah,
possible.
yeah.
Yes, yes, yes.
Yeah, it all depends on
The pendency. Yeah, yeah.
the
First,
workload, the bench, and those things. Yeah. Yeah, yeah. But it is expected, at least initially, when the benches are new, when the cases are start getting filed, of course, things will be very expeditious. But only if if there's a workload and there are thousands and thousands of appeal file, of course, everything will then go as per the judicial process, as has been the case. Yeah.
yes, Sumit, we may expect a lot of hearings to take place in first few months, whereby
Right.
they are hearing the matter. We may not have decisions very fast.
Right. 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 Okay, and okay, so now we will see. We have not done this till now, but I'll try my best because two people have raised hands. Let me see if they are still. I'll try and spotlight them. One second. No, one of them I can't find. Let me find. No, I can't find somehow. Okay, so they may have just recently quit. So I think
Would have
any
resolved
other
their issue.
question, if anyone has, or Rajat, any concluding remarks you
So
would like to
I
give?
think, Sumit, we would have resolved their issues.
We would have resolved the issue. Yes. Any concluding remarks, Rajat, on
So
this?
for a lot of professionals, I think this is a very big opportunity going forward. We'll see few thousands of cases in every state. every professional will have a great opportunity. Like, the moment GST came, there was a lot of opportunity for our brothers and sisters working in the field. So whether a person is an advocate, chartered accountant, or a cost accountant, or a company secretary, they can appear in a tribunal. So the only point is who starts first. So the
Right.
provisions are simple. You know the law, you know your client, you know your facts. The same facts are to be given in front of a two people bench. So everyone can initiate this. So happy to help anytime you want my assistance or want to know anything, I'll be happy to help.
Yeah, and also do look at the books authored by our speaker Rajat Mohan. Rajat, if you could name the books again,
So, so,
fragment
so
the
one
book.
of my book is GST for corporate leaders. There is a pretty slim book, 300 pages for high level, decision making directors or CFOs, CEOs. The other book that I have made eyeing only tribunals is a GST case digest. This is a big 3,000, 4,000 pager book. We have analyzed over 11,000 cases and in in a section wise, subject wise manner. For example, if you want to search section 17, then you can look into input tax credit, whether allowed for a mobile phone or not allowed for a mobile phone. You will have both the sides of judgment saying it is allowed, judgment saying it is not allowed. So in tribunal, the reverse cases also works. You need to know what department may use against you. So all
Right, right.
these 11,000 judgments or so has been analyzed and briefed in a section wise manner. This could benefit you.
Awesome. This is wonderful. We'll just have a closing poll and then we'll close the webinar in the next few minutes. I'll just launch the closing poll. Okay, so we discussed about COMPLINITY, the video, and as well as what we talked about. So if you would like to have a demo of the COMPLINITY compliance software, if you're coming from the corporate side, please indicate your choice here, and my teams will then reach out to you. And would you like to be a speaker in future COMPLINITY webinars? COMPLINITY keeps on organizing webinars on contemporary legal and compliance topics. This being one, since the GST tribunals now are very soon going to see the light of the day. So we invited Rajat Mohan as the practitioner in GST and also as a leading author on these books. So we keep doing webinars on competition, on DPDP, some of the past webinars on POSH, and other contemporary areas. So if you'd like to be a speaker, again, please indicate your preference and we would reach out to you. Yeah, I'll just wait for 30 more seconds. If you could very quickly indicate your preference, yes, no, yes, no. And we'll close the webinar. Okay, on that note, so thank you everyone for a patient listening, and thank you for attending in good numbers, and thank you Rajat for taking time out for briefing our audience, for such an important topic. So thank you Rajat,
Thank you,
and thank you
Sumit.
to my
Thank
team
you.
for organizing this. Thank you.
Thanks.
Bye.
Thanks, everyone. Bye.
Bye.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.